Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello and welcome to the 6th episode of Stephen's Squibs Family Law Monthly Case Law CLE. And with me again, of course, I have CARYN Stevens and GINA SZAPUCKI. How are you guys doing today?
Hey, good morning. Happy New Year.
Happy New Year.
Can you believe it's 2020 and this is our 6th edition of the CLE?
Well, it's 2021, thank God, and not 2020 still.
I have not wrote that on any checks yet. So what I meant to say is it's a brand new year and so many exciting things are happening, including all of these great appellate cases that came out. So why don't we jump right into the material? This is an exciting edition because we're going to be joined by CRISTINA MALDONADO. But first, you should all have the materials in front of you for the November cases that came out. Those are the ones we're going to talk about, starting with the first case, Rotunda v. Rotunda. CARYN?
Yeah, let's go. So Rotunda versus Rotunda is a case out of the 5th, and I'm going to talk about the first 2 cases, which are attorney's fees cases. The opinion in Rotunda is real short. Basic premise is these folks went to trial. The appellant was awarded attorney's fees for the first 3 days of trial, but for some reason she was not awarded attorney's fees. There was no consideration for the fees that were incurred on the last day of trial, and there was nothing on the record to support why those fees had not been awarded to her. So it was reversed and remanded back down with directions to the lower court to figure out exactly why you hadn't taken into account the 4th day of trial. The next fee case, number 2, is Coriat versus Coriat, and this is a case out of the 3rd district. And this comes from a long line of cases that we see all the time, and it all relates back to the seminal case, which is Youngblood, which is the case that stands for the proposition that when you're seeking fees and being awarded fees by the court for your time, you cannot be awarded fees and costs are really just fees related to secretarial and clerical work. There's a very big difference between a paralegal and someone who's actually providing litigation and necessary litigation support to a case. And Youngblood's a case that's been around for many years now. We had an appeal recently that involved a similar issue, and we had to concede that some of the fees that were awarded were for clerical and secretarial work, which is exactly what happened in Coriat. The former wife did concede that some of it was for those sorts of work, and it was reversed, and the court agreed that you cannot award for clerical and secretarial fees. So beware, make sure your bills are really clean and clear when you're trying to deal with seeking fees.
GINA, you want to talk about deductions in a paycheck?
Yes. So the first child support case is Buck v. Buck. It is a case that's out of the 2nd district, and this was a modification of child support. The issue here was that even though the final judgment clearly stated what both parties' incomes were, it failed to explain how the court arrived at those income numbers. So this case is good where if a judge or a magistrate is asking us to draft proposed orders, always remember to put in those findings as to how we get income, so we don't have reversals in these situations. CARYN, you want to talk about the next child support case?
Yeah, so the next case is O'Neill versus O'Neill. This is a case out of the 4th district down where we all practice, and this was a case that was appealed by our friend R.T. White. And O'Neill is also number 7 in your materials, so I'm going to talk about it in conjunction together. It had some interesting teachings about child support and some interesting findings as to equitable distribution. So I'm going to talk about both of those. But O'Neill was appealed. There was a multitude of issues appealed by the husband, including equitable distribution, alimony, life insurance issues, attorney's fees, and a reservation of jurisdiction issue. The former wife did a cross appeal, and she appealed on a child support issue. So this was all heard and addressed by the 4th district in conjunction together. But what O'Neill teaches us and stands for is the fact that at trial, the parties stipulated to 50-50 time sharing. okay, on the record. However, once the husband started testifying about his actual ability to exercise time sharing, he testified that he travels for work like 200 days a year. And that was all very clear on the record through his testimony. And the trial court still awarded child support on a 50-50 time sharing basis, even though there was clear and substantial and competent evidence through the husband's testimony that despite their wonderful stipulation that they wanted to do 50-50, he was never going to be able to exercise that. So it was reversed, remanded back to the court on the child support issue to say that child support actually had to be calculated on what they were actually doing and not just this theoretical, oh, well, they're going to do 50-50, when it was clear that the father was never going to do that. On the equitable distribution side, O'Neill was also affirmed in part and reversed on part of some of it. But the thing that stood out in O'Neill about equitable distribution is that the husband took the stand and he testified that his, I think it was a BMW vehicle that he had negative equity in it. And he testified, it was indicated on his financial affidavit. And what the court said is that a financial affidavit and the testimony by a party when he has intimate knowledge of the asset he's talking about, if there's no expert testimony, that's good enough substantial competent evidence to support the fact of what something was worth. And the husband clearly said his car had negative equity, but when the court fashioned its equitable distribution scheme, it failed to take into account that his BMW was worth a negative amount and not a positive amount. So that was reversed and remanded back, and the court was told to take into account the negative equity issue. Some other discussions about the other issues of life insurance and attorney's fees, but those two were really what stood out and we took away from that case.
So if you want to challenge someone's value on their financial affidavit, you really have to come up with something, or the court's just going to use that number.
Yes. And there was a pretty good discussion about that, that a party can testify and nobody had anything to contradict it. So.
And there's also those fun cases that say a party can testify as to the value of real property if they own it, only if they own it. So good practice tip there. That's going to take us over to enforcement. We had a fun contempt case where a gentleman was held in contempt for not making a lump sum alimony payment, and the purge amount was $621,000. What struck me first was when I read this case, I wasn't sure if you could be held in contempt for not making a lump sum alimony payment. So I looked it up and I reminded myself with the Pipitone v. Pipitone case, and it's 23rd Southern 3rd 131. It depends if lump sum alimony is meant for support or alimony. It is enforceable by contempt. If it is for equitable distribution purposes, it is not enforceable by contempt. This case doesn't address it. I just thought that was that was the first thought that popped into my head. In this case, the former husband did not attend the contempt hearing, and the court just put the full amount down as the purge payment. And we have this rule of family law procedure, specifically 12615, that requires the court to set a reasonable purge amount based on the individual circumstances of the parties. Since the court did not even take that into consideration, the matter was reversed and remanded back for redetermination. So if you are going into a contempt hearing and the other person is not there, you still have a duty to put on the evidence to demonstrate what that reasonable purge should be.
So the next case is under also enforcement, which is the Lynn versus Landsman case. And this is out of the 1st District. And this is a good read. And this case sort of follows the line of cases similar to Keitel that talks about enforcement of contracts and marital settlement agreements and parenting plans. And if you're not familiar with Keitel, the site on that one is 716 Southern 2nd 842. And that's an important case to read because what it discusses is that in order for something to be enforced in a contract, it must be clear, definite, precise. And what happened in this case is that there was an agreed final judgment parenting plan. And what the parenting plan actually said is that the father or each parent was entitled to reasonable contact or reasonable communication with the minor children while they were time sharing with the other parent. And I am sure that I and many of you have written parenting plans like that, where we say, oh, they have open access, reasonable contact with the other parent. And what happened in this case is dad wasn't getting his phone calls when the kids were with mom. And like so many parents, he decided that the only remedy he had was to go to court and ask to enforce that part of his parenting plan. And what the court said is that because the language just said frequent and, reasonable communication, that wasn't clear and precise, and it wasn't enough for the court to enforce the contract because it didn't put mom or dad when the kids were with mom, it didn't put mom on notice as to what exactly her obligations were as a parent. And I can see both sides of the coin on that one, but the mom was found in contempt at the lower court level, and she appealed, and that's what it came up before the first district on. And they said that mom did not willfully violate an order, because how could she willfully violate something that wasn't clear and precise to put her on notice of what she was supposed to do or not do? So good practice tip to remember when you're writing. I can't tell you enough times that I've written things like that, and we learn every day in this practice, but be more clear and precise. Try to lay out time frames, try to lay out manners in which people are going to communicate with their kids, how often, what's reasonable. Otherwise, you're going to deal with something like Mr. Landsman dealt with in this case, which is inability to enforce it. And it looks like we did the equitable distribution case number 7 already. So now we're moving into injunction world. And I think Eddie has the first case in injunctions.
Thanks, Karen. We have 3 injunction cases this month. The first one was really interesting. Helwig v. Bugbee is number 8 in your materials. This is out of the first DCA, but it dealt with an indefinite injunction over a former husband's 3 minor children. And basically he said that denied his or took away all of his parental rights and denied him of due process. In this case, final judgment was entered. Former husband had 40% of the overnights. The allegations of domestic abuse arose from incidents that occurred during the minor child's time with dad. In the petition filed on former wife or mother's behalf, she alleged that dad had ongoing and increasing anger management issues, including frequent tempers and angry outbursts. The former husband did not allege, no violence was alleged against the former husband. This injunction was entered in favor of the 3 minor children and the former wife, because the former wife did not allege any concerns. That part of the injunction was reversed, but we're going to learn why the injunction was affirmed for the 3 younger boys, even though it effectively terminates the time sharing between dad and kids. The allegations were dad grabbed a child's wrist and another child's arm after the children failed to follow his instructions. It was also alleged that the husband yelled at the children during these incidents. The petitions expressed concern for the children's emotional, psychological, physical safety. The petitions requested that dad be prohibited from time sharing with either child. So those allegations on itself, a bruised wrist, a twisted, a grabbed arm, a grabbed wrist, those do not seem to me to be allegations that would support, an indefinite injunction. But some evidence came in, evidence that, and really this was described by the appellate court as Indian burns. When you give someone a little rash by twisting their skin in different directions. The wife testified over dad's objection that she received a diagnosis and treatment plan. from a therapist to examine the children. A bunch of children hearsay statements came in. There was also the judge interviewed the children, got their perspective. There were also hearsay statements of the children that were, they reported assault. Those issues were not, those hearsay objections were not brought up in the appeal. I don't know if there would have been a different result because these hearsay statements in the plan actually showed a detriment to the children and really bolstered the petition. The case states out the standard of review, and this was new to me. I thought it was abuse of discretion, but whether the evidence is legally sufficient to justify imposing a DV injunction is a question of law reviewed de novo. So whether or not the evidence is legally sufficient is not an abuse of standard review. So that's a good case for that. And again, the appellate court agrees there's no evidence whatsoever to support the injunction against the wife. But then it comes down to whether or not this indefinite injunction eliminated dad's ability to be a parent. The appellate court explains what the termination of parental rights are. A permanent termination of a parent-child relationship is a constitutionally protected fundamental liberty interest. The grounds for termination of a parental right are in 39-806 in our dependency statutes. They include showing of abandonment, abuse, or neglect by clear and convincing evidence. The trial court must also engage in a manifest best interest of the child and least restrictive means analysis. All these steps serve to provide crucial safeguards in place to protect the natural right. The thing that made it a little complicated, the court, when entering the injunction, quoted, "Now here's the conundrum I face with all these findings. If I grant the injunction, I make it permanent. I'm essentially terminating dad's parental rights. I don't know how to look at it any other way, but I don't see, because the way things have progressed, that I have any other choice." But the final judgment of injunction did not terminate the father's parental rights in accordance with 39-806. And the appellate court says no due process rights were abused because in an injunction, you can always go back and modify or dissolve it at any time. And that's pursuant to 741-30 sub 6 sub C. So the former husband's argument that this injunction terminated his parental rights was misplaced, and there's a really good explanation as to why that is. CARYN, back to you.
Okay, so the next injunction case is also out of the first district, and this is the Mack versus Mack case. And this is sort of the opposite of the case Eddie just discussed, although they're both out of the same district. And interestingly enough, the Mack case also pointed out what Eddie just discussed, that the review, any appeal, it's reviewed for de novo and not an abuse of discretion. So they had a case back in 2020 in the first district, the Whitlock case, where they stated that any question of evidence sufficient to justify imposing an injunction is reviewed de novo. So if you're practicing in the first district, that's your standard of review on an appeal of an injunction. But in the Mack case, what happened is mom sought an injunction on behalf of herself and the children, and the court granted in favor of mom this injunction. And these folks that had a history of being in front of the court for their dissolution of marriage, some enforcement issues, some other situations as well. So the court was sort of intimately familiar with them. But the problem was that there was no allegations and no evidence presented and nothing on the record to support that the children were in imminent danger of becoming victims of domestic violence. All of the evidence and everything on the record and all the allegations had to do with the father harming mom or causing imminent fear to mom that she was going to be harmed by him. So the injunction was reversed as to the children. So sort of the opposite of the case Eddie just discussed. So the injunction was affirmed on behalf of mom and reversed on behalf of the children. There's another injunction case out of the 4th that GINA is going to handle next.
Thanks, CARYN. This case is Cash v. Gagnon, and this was a stalking injunction, which, not as common as domestic violence. And the issue in this case was there were, 2 parties that were both living in the same condo. They were both on the board of directors, and things started to heat up when one of them wasn't reelected, just to give a background story. Throughout that time, there were multiple instances of verbal altercations between these 2 parties. For example, one was, interruption, yelling at him over a boat dock. There was another where he was yelling about how the landscaping wasn't properly put according to the condo association's rules, and so on. There were multiple instances of verbal altercations, but there was nothing physical. Here, the judge found that, this did classify as stalking. It was brought up, and it was ultimately reversed, and said that based on, majority of these were verbal altercations and could not be classified as harassment in a stalking injunction. In order for something to qualify as stalking, you have to meet 2 requirements, okay? And the first one is that the conduct has to cause substantial emotional distress, which is greater than just an ordinary feeling of distress. The second thing that you would have to prove is that there is no legitimate purpose to what was happening. Ultimately, the appellate court found that majority of these verbal altercations did have a purpose because they were discussing condo issues. And, this case is a wonderful case to read because it goes way more in depth of what the court defines as harassment, what emotional distress is classified as. So this is a wonderful case just to get more knowledge on, what you would have to prove in how many instances and things like that. And I believe we are now on the jurisdictional case. Eddie?
Thanks. I get all the fun Hague cases, and number 11, which is Cruz de Carvalho or just de Carvalho, and it's out of the first DCA, and it dealt with the Hague Convention and the habitual residence of a child that was born in the United States and never returned to any other country. So the case starts off with a discussion of the importance of the Hague Convention, the purpose, the fact that the convention's central operating feature is the return remedy. When a child under the age of 16 has been wrongfully removed or retained, the country to which the child has been brought must order the return of the child forthwith unless certain exceptions apply. This return remedy is meant to advance the convention's core premise in the interest of children. In matters relating to their custody are best served when custody decisions are made in that child's country's habitual residence. The convention is intended to ensure the rights of custody and to access under the law of one contracting state and effectively respected in other contracting states by providing a return to the status quo and to deter parents from crossing borders in search of a more sympathetic court. The convention seeks to deter parental abductions by eliminating the prior motivation for abductions, which is to obtain an advantage in custody proceedings by convincing them in another country. While this case does not involve abduction or removal of the child, wrongful retention in the habitual country of residence is subject to the same anti-form shopping remedy provided in the convention. To establish a case for wrongful retention, you must show by a preponderance of the evidence the children were habitual residents, in this case of Brazil, the country where one of them was born. At the time, they were retained by the mother in the United States. 2, The retention of the children by the mother was in violation of the father's custody rights under Brazilian law. 3, the father had been exercising those custody rights at the time of the retention. The parties stipulated to 2 and 3, so the only issue for the trial court was whether Brazil was the habitual residence of the children when the mother retained them in the United States in breach of the father's custody rights. Hope you're with me so far. The standard of review is clear error for these type of determinations, the habitual residence determination. And that's a task for fact-finding of courts, not appellate courts. And they should be judged on appeal by a clear error review standard, giving great differential to the trial court. The determination of a child's habitual residence depends on the totality of the circumstances. It is not a bright line case. So let's talk about the issues in Carvalho. Mother and father were married in Brazil in 2010. Child 1, born in Brazil, 2012. Mother became pregnant with child 2 in 2015 in Brazil. In January 2016, the parents, child 1 and another child from another relation traveled to the United States for 2 agreed upon purposes. First, child 2 is going to be born in the United States, so he would have citizenship. Second, for the father to advance his cardiology career by participating in a temporary medical fellowship at an American hospital. The family rented a home from January 29th, 16 to March 24th, 2016, about 2 months. Child 2 is born on March 2nd, 2016, so in that little window. Unfortunately, by the time child 2 was born, the father's cardiology fellowship fell through, and the father returned to Brazil alone March 10th, 2016 to reestablish his previous employment and to stabilize the family's living situation. The father purchased plane tickets for the family to join him in Brazil. Mother refused. So here the court was faced with a very interesting issue. You have a child who has never been to Brazil, was born in the United States, and has no personal ties to Brazil, being found to be a habitual residence as contemplated by the Hague Convention. And the courts basically, the appellate court majority decision, because there is a dissent, basically says, in cases involving infants born in a country during a temporary visit by the parents, the Supreme Court has noted that an infant's mere physical presence, we agree, is not a dispositive indicator of the infant's habitual relation or residence. Justice Jay concurred in part, dissented in part, and dissented as to child 2. And basically said child 2 is a United States citizen. He was born in the United States. He always lived in the United States. He has never lived or even visited Brazil. Brazil is not his habitual residence. He was not wrongfully retained by his mother in the United States, and there is no legal basis under the Hague Convention to return him. So it was a pretty heated opinion, and that was the result. Even though the child had never been to Brazil, it was affirmed that that was his habitual residence. Now that is going to take us to modification. Thank goodness we only have one jurisdictional case to talk about. And we are on case number 12, which is Lyles v. Guffey, also out of the first. And it dealt with a modification, and pretty short. They found that a person's move from one state to another was contemplated or was anticipated, and basically denied the modification for that purpose. Pretty simple case. That takes us to 13.
Okay, and case number 13 is Romeo versus Romeo. I hear Juliet in my head from high school literature, but this is the second DCA's case, and this modification case, it's without sounding too disrespectful, it's sort of law 101. So in order to have a modification, you got to prove that there's been a substantial unanticipated material change in circumstances since the entry of the last order. And this case, this lower court judge did not include any findings that there had been a substantial material unanticipated change in circumstances, period. So the court could not grant a modification without that pretty law 101 finding. So it was reversed, and that's what Romeo teaches us. So if you're submitting proposed final judgments, folks, remember to include that language.
My bounty is as boundless as the sea, my love as deep. The more I give to thee, the more I have, for both are infinite.
That was an excellent quick Google search there, Eddie.
I think that's awesome to be quoted in a case about divorce. Woo.
Yeah, right.
Sorry. Later. After that bag of laughter, that takes us to case 14. I don't know how to say this. Storn, some Swedish name.
Sodren.
SJOGREN.
Try Sodren.
Blah, 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 blah. It's out of the fourth.
That one.
This one.
So in this case, we dealt with a temporary reduction in income, and the guy filed for modification and basically had some deductions being taken out of his paycheck until 2024. We don't know why. It doesn't really explain if he owes the company or if he's being garnished or whatever. But it's temporary. So the court denied the modification, but reminded everybody that under these circumstances, a court will grant a temporary reduction or suspension in alimony when the obligor has suffered a reduction in income without deliberately seeking to avoid paying alimony and is acting in good faith to return his income to a previous level. So that's different than a supplemental petition for modification. I think that that's probably a motion that can be filed post-judgment, but there has to be the expectation that income is going to be resumed, because otherwise you should file the modification. So those are all the cases that came out of all the courts in November 2020. Yay. We also have some disciplinary proceedings.
And now, a discussion of the Florida Bar's disciplinary orders since our last meeting.
Real quick, we had 11 attorneys disciplined in November of 2020 for 4 disbarments. The disbarments dealt with number one, the attorney misappropriated $20,000, failed to respond to bar inquiries, failed to meaningfully participate in disciplinary proceedings. So if you misappropriate 20 grand and you don't participate, expect to be disbarred. 2, the guy abandoned his practice, moved to another country, didn't respond to the bar. That will also lead to disbarment. 3, Lewis, the attorney, neglected 4 separate matters, failed to deposit retainers and cost deposits in his trust account, and failed to promptly return unearned fees and costs to clients, and failed to maintain required trust account records. Seems pretty obvious. Number 4, attorney disciplinary revocation, which is tantamount to disbarment. Attorney issued a check representing settlement funds, but he wrote it from his operating account instead of his trust account, and it bounced. In another matter, so this is a accumulation of complaints. He was charging a client for an appeal. The appeal was denied 2 years ago, and he kept charging the client as if the appeal was still in existence. So he lost his license through disciplinary revocation. One more revocation of case 5, attorney misappropriated $53,000 and was charged with grand theft. I guess that would do it too. 6 was kind of it seems like a harsh penalty. I don't know if this particular attorney has a previous history, but he made a misrepresentation under oath regarding his entitlement to legal fees and got hit with a 3-year suspension.
Must have been a heck of a misrepresentation.
Yeah.
Well, be careful what you say. And you can easily look up the opinions just by Googling the information and the materials here, and you get to see the full report and recommendation if you guys are interested. Number 7, we have a 1-year suspension because the attorney was held in contempt of court for failing to notify everybody of his suspension. So whenever you violate terms of your suspension, like notifying it, they up you up to the next level of discipline. So he was probably suspended for something less than a year and now is suspended for an additional year. Number 8, the good old, let's talk about our opposing counsel on social media. Oy vey. I mean, we saw the attorney disbarred 2 months ago. In this case, the attorney made numerous derogatory remarks on Facebook about opposing counsel and in a client review on AVO. In her post, the attorney also made misrepresentations regarding the judge's comments about opposing counsel and so on. It's not good to do that.
Never the way to go to post those false AVO reviews. Never the way to go out.
Well, there's a great case out there where someone was hit with a $300,000 penalty for writing a inaccurate review about an attorney. So I always keep that case handy when I see inartful AVO reviews going against my friends. It's helpful.
And remind your clients that's not the way to handle an unruly opposing counsel on the other side by posting false things on that attorney's AVO.
And if you post it on Google, your name's attached to it.
Right.
Yeah.
Right. We might have had that experience recently. Might have. Not our client.
Number 9, we had a 91-day suspension because an attorney made misrepresentations about his availability. So he's playing that don't set this hearing now. And apparently he didn't properly supervise his non-lawyer staff. So you can see how that could get you in trouble. There was a 10-day suspension, number 10, for 10 days. After being appointed counsel for defendants, the attorney failed to appear in 2 criminal matters, and his clients were unable to have their matters heard as a result. Number 11, a reprimand, and this is where an attorney failed to communicate, took on matters he wasn't really qualified for, but eventually got some guidance and joined a firm where they took it over. So this attorney was just reprimanded. So that is your November case law update and disciplinary reports. And now we have a very special guest, CRISTINA Maldonado, and I am going to have a great discussion with her about the ethics of mediation. Speaker view. And to end this January edition of Stephen Squibs, we have a very special guest with us, CRISTINA Maldonado. I have known CRISTINA because she's mediated a bunch of my cases. She is with the Upchurch, Watson, White, and Max firm. Her entire legal career, 9 years, have been dedicated to alternate dispute resolution, where she's mediated over 1,800 cases, and I think she's trained over 100 mediators. She is passionate about helping people find their own solutions. I can tell you that from personal knowledge because I have seen it in action. Ladies and gentlemen, please welcome to our show, CRISTINA Maldonado. Thanks for joining us and
thanks for having me.
we're going to drop some ethic mediation credits on our folks today. So before we do that, can you just tell us a little bit about yourself?
Sure. You covered a lot of it. I was a mediator before I was a lawyer, because before going through law school, I did a master's in conflict resolution, and I met a lot of people who were like introducing themselves as recovering attorneys after 20 or 25 years in the trenches, as it were. So when I then went to law school, I was like, I want to start there. So I did. And I've been a mediator for 10 years, and I mediate family, dependency, circuit civil, and county cases. And I teach. I am certified to teach family and circuit civil as well.
Cool. So let's talk mediation ethics, and let's start with big picture stuff. So tell us a little bit about mediations in Florida.
Sure. I was at a CME recently that the Florida Justice Association did, and they had Justice Barbara Parente talking about her career and her life. And she mentioned that her first mediation was in 1992, ever. And that just doesn't feel like that long ago. She was sort of describing this wrongful death with a case with a retired judge from Pennsylvania. And so for a long time, it was sort of seen as the purview of retired judges, et cetera. But Florida picked up on mediation really early on. And so they sort of took the ball from this whole idea of the multi-door courthouse that came out of Harvard, getting to yes, all of that stuff that came out of the Harvard Project on Negotiation, and put it into practice down here and really institutionalized it early on. It's really more fleshed out in our state than it is in a lot of other parts of the US. And so people come here to learn how to do it and then go back to other places. So
I remember getting to yes was part of our actual curriculum in law school. I went to Stetson in the 90s, and that was one of our textbooks.
It is. It's, the story of the orange, right? The two sisters fighting over the orange, and how can you get more than half of the orange? In family law, the kids are the orange usually in some way, shape, or form. How can you figure out how to get more than 50% of the time? How can they get the zest and the juice out of both parents? What can you do to make it go well or go better? So it's absolutely applicable.
What are some of the statutes that we deal with in Florida, and speak a little bit towards that if you can? Sure.
Mediators in Florida have to go through training, which is laid out by the administrative orders in the Supreme Court. And so, and in parallel, the ones that govern the actual process, and that's not just family mediation, it's all kinds of mediation. It's every different type of mediation that goes on that is court ordered specifically, falls under Chapter 44 of the Florida statutes, which includes the Mediation Confidentiality and Privilege Act. Whenever you hear people say all mediation is confidential, they are only saying half the sentence. It's my personal pet peeve, because there are exceptions to mediation confidentiality. And the actual, the privilege in mediation confidentiality is a privilege, and it's held by the parties. And that's not something that people necessarily stop and think about. It's a little different than like when you have attorney-client privilege with one of your clients that, you can't talk about. You're bound, right, as a lawyer, right? You can't talk about what you talked about with them, but they can tell anybody they want about that conversation later in your life. And with respect to mediation confidentiality, the sort of cone of silence descends on the whole process, and all of the participants who are inside are bound by it. In the era of blended families, and in the era of social media and phones in everybody's pockets with text messages, that can get a little fun as far as the ethics are concerned. But the whole point is to be able to keep that process informal, and so that people can talk about what they need to talk about when they're protected by that veil. Another piece of the we have the civil procedure rules, right? We have the family rules, civil procedure, and the circuits, and just the broad rule of civil procedure, Florida rule of civil procedure, that govern when mediation starts, when mediation ends, what an appearance is, how you get to pick your mediator, how do you get to How do you get to communicate with them, et cetera? So those are the parameters that are laid out there. And then the mediators themselves have a code of ethics that governs our behavior. And that's Rule 10 of the Supreme Court. And so it's the beginning part is all about how to get certified. The middle part is how to behave in mediation and how to handle the ethical situations. It's almost like the professional rules of responsibility for attorneys, but for mediators. And then the last part of that of Rule 10 is what to do if you get, what's going to happen to you if you get in trouble, what the disciplinary processes are.
So what institutional entities do we need to know about that are kind of related to mediation in Florida?
Sure. The entity that certifies mediators in Florida is attached to the Florida Supreme Court. So it's called the Dispute Resolution Center. They've been around since the late 80s. And so when mediators go through their 40-hour course, they then have to basically, it's almost like applying to the bar. You have to send in your transcripts and copies of your degrees, and you have to have sat in on other people's cases. So if you ever have somebody watching in there, it's no different than, when you go to the doctor and the doctor has a resident sort of sitting in on you. It is always a challenge to get people their observations. So you often have people asking to see if that can happen. Once they've got they go through background check, FDLE, they have to disclose any issues that they might have that have to do with like good moral character. And so that whole package gets sent to the DRC and reviewed. And if they let you in, you get your certificate signed by the Chief Justice of the Supreme Court. And then you have to do 16 hours of continuing ed every 2 years in order to stay up to date. So with emphasis in areas that very specifically, I would say, affect family, like interpersonal violence and diversity and the ethical side, of course. So
can you tell me a little bit about, what you would consider the characteristics of a mediation?
A mediation, the core three are that it has to be, you're a neutral facilitator, right? The mediator is a neutral facilitator and the parties are the decision makers. That's so different than when you're in a situation where it's like, all rise, the Honorable Judge A. Stevens presiding, and today's courtroom. Okay, so now you get to talk. Now you get that whole dynamic is a lot different than, hi, I'm your mediator today. Welcome to mediation. Today's your day, right? That's the whole point of that whole opening statement that the mediator goes through. The lawyers have usually been in it a bunch of times, so they've heard it before. But it sets the groundwork for parties to kind of realize that they have this opportunity to shape the way things are going to go going forward. And so there's a line of theory about small group dynamics, and it's that small groups, when they come together, they're formed, right? The very first phase of those small group dynamics is known as storming. So there's this huge explosion of, emotion and things of that sort, and brainstorming of ideas, and just sort of everything comes out on the table. Then the next phase of those group dynamics is norming, where you're sort of starting to fit the pieces together and figure out how it is that it's going to work. And then the later part, hopefully, if you're heading towards an agreement, is this performing aspect, where you start writing it down, putting it in terms of how it's going to be going forward. And then everybody kind of goes off into the rest of the world. And mediation is definitely that kind of process. It's a voluntary process, so right, again, it's different than the court, because people get to say yes to a bad deal. They get to say no to a good deal. This is infuriating to some people who are like, why aren't you taking this, right? But that is sort of the nature of self-determination. You're trying to run this process that is free from duress or coercion or anybody telling you what you got to do. In a properly conducted mediation, it is the parties who are exercising that self-determination. And we talked about confidentiality a little bit before, so those really are the three pole stars, right? A neutral party, a voluntary process, and a confidential one.
So how would you go about choosing a mediator, and why do you think that certification versus someone not being certified is an important aspect?
Sure. In self-determination itself, I think determines that people can choose whoever they want to be their mediator. And Florida law allows that. You can choose your priest, rabbi, religious leader to be, trusted friend, trusted whoever. Anybody can be your mediator. That said, the people who are certified by the Supreme Court are, number one, they're protected by immunity granted to them in Chapter 44, pretty similar to what judges have. And if it's under a court order, that mediation is governed by the rules of procedure, by Rule 10, by mediator ethical rules. And so somebody might be mediating non-certified, but pursuant to a court order, and they may not be as familiar with the rules that they're supposed to be following. Why does anybody specialize? What's the difference between a board certified attorney and somebody who isn't, right? There's somebody who puts some extra time into learning about their field, their profession, their craft. And so it adds that. I think what it boils down to is it goes beyond the trust that people have in a person to sort of a stronger guarantee that that process is going to be run well.
And since you brought it up, the order versus a notice of mediation, can you briefly, tell our audience the importance of ensuring that a mediation is set by order as opposed to just a party noticing it?
I think it basically calls into presence the rules. Like it activates the rules. Court ordered mediation is held under Chapter 44, under Rule 10, unless the parties expressly choose to waive some or all of the applicability of those rules. They can say that they don't want this part of it to be affected by the rules. I've seen different instances of it. I had one unusual situation that was recorded at the end for reasons of it was an older person. They didn't want capacity to be contested. And so there was writing in place that said in the event that the mediation confidentiality for that signing ceremony would be waived, right? So you can carve out pieces of it. But if you're doing like a pre-suit mediation with an uncertified mediator, Chapter 44 is not in effect. And so you need to have some kind of confidentiality agreement signed if you want those protections to be in place. And so if you want to make sure that all of the elements of mediation are there, it does help to have, an invocation of the rules, ideally with the order, also by contract, but just making sure that you're taking care of it when it applies and when it doesn't.
And how do conflicts of interest work in mediation? Can you waive those? Some of them.
You can't mediate for immediate family and friends, or really for the people who are in your firm. So conflicts of, there are some that are waivable, but I think people need to be careful with respect to staying neutral. The longer we're an example of this, I guess. Over the course of 10 years in practice, I've met other attorneys who work in our geographic area, who may be perhaps what I would refer to as the recurring characters of each other's soap operas, just people that you see more than once and done. It's a natural thing to say, hi, how are you doing? Over time, you may learn something about this person's life, right? I think as a mediator, you need to be careful to guard against the slipping of your neutrality. That sort of, when you walk into a situation and you see the mediator greet the other side with a lot of familiarity and just say sort of hi to you because they may not know you as well, that whole perception of neutrality can be affected for everybody's clients, right? One side thinks, hey, I've got this in the bag, and the other one says, what's going on here? So really it pays to disclose. The burden is on the mediator to disclose any kind of connection that they may have with people, and the choice is in the hands of the parties, whether they want to waive that conflict of interest. But it is important to do any kind of disclosure that could affect the perception of neutrality. It's an appearance of impropriety kind of thing.
I think just beyond appearance, I always have issues when I represent people I know. 'Cause sometimes I lose my own objectivity, and I those have probably been the biggest challenges dealing with things like that. And it would have been so much easier and more pleasant if I just said no in the first place, instead of just trying to be helpful. So those boundaries, I think, are really, really important.
People can waive them, but I think what you're saying now is should you, in some cases. And as a mediator, if you say yes, and over the course of a mediation, you reach a point where you're like, I really can't do this. I'm not doing people justice. Then you have the obligation to sort of say, you know what, even if people want you to keep going, you're like, I can't do it. I'm not doing it right. So I got to stop. I think the rules give you that out, to the extent that you do your best to try to conserve your ethics in place. People have some unhappy people, but it's the right thing to do.
In your sanity. So yes. Speaking of sanity, we've been experiencing a whole new way of doing things since the pandemic. And, that has always been interesting, presenting issues with court, presenting issues with depositions, and of course, confidentiality and issues in mediation. And how are you handling that right now?
A couple different ways. I am the host of my Zoom meetings, so I have turned off everything that allows for recording and mediation. There's no record button on my Zoom for me or for my participants. That doesn't mean somebody couldn't, do something like that with a phone or something like that. But I think that would have applied even before and in person if somebody left the phone sort of discreetly running. So ever since we got smartphones, I kind of punched a hole in it. I've done camera sweeps, sort of where the camera goes, the whole 360. Because I'll see people kind of go like this, or somebody walk through the background. And at that point, I'll sort of stop and I'll be like, I just wonder, I know everybody's at home because you can't not be understanding of the circumstances we're in. But I've had people attend from cars, bathrooms, trying to carve out a place of privacy in their home where they're trying to get some peace and quiet to go through this process. And I try to enlist the attorneys as my virtual bailiffs, as it were, because I'm not when you caucus, you're not in both rooms. And so you can't guarantee all of it. So I asked the attorneys, please help me make sure that no third parties enter here without the consent of the other side. I would do the same for you in the other room, if there was any kind of an issue like that. Caucus confidentiality, there's that confidentiality sort of cone of silence. There's an inside mediation, that says to the rest of the world, but when you're dealing with the two sort of bubbles inside that cone of silence, mediation confidentiality dictates that you have to be allowed to say what you're saying in the other room, and you're not allowed to kind of run over and tattletale, as it were, unless you have permission to do that. But you kind of have to give people the opportunity to solve it, because as a mediator, you don't want to be in a situation where you're sort of being used by people incorrectly, right. Where they're sort of wiping their hands on you for whatever dirty deed they're doing. So please don't do that to us. It's not nice in general, but it takes that said, we're not going to rat you out. I think that's what it boils down to. It
takes a village to get through this, and surviving, yes. and being a little more patient, and the Zoom issues, and oh my goodness. So we've talked a little bit about how the sausage gets made. Mm-hmm. Let's talk about who gets to be in the room where it happens. Who are the participants in a mediation?
A participant is anybody who has been agreed upon to come in, right? You have the parties, you have their lawyers, guardians ad litem. Those people get in. Interpreters, they get in most of the time. Sometimes people argue that's not a real interpreter, that's a family member. or I don't want your teenage son being the one who's, or our teenage son in some instances, being the one who's running all of this, because you're sitting there listening. You say, 2-3 sentences and the person communicates 2 words, and you're in trouble then at that point in time. But people want a lot of other people to come in with them, parents, new spouses, significant others, friends who are there for moral support, experts sometimes, right? When somebody wants to bring a financial expert or somebody else, or a counselor. I've co-mediated with a parenting coordinator in the past in a couple of instances. The kids, there's actually an ethical opinion now that says that if the parties want the children in, the children can get into mediation. There's a mutual agreement that that the kids can come in. That's allowable. Mediators it's advisory, so it's like best practices kind of stuff. But just sort of whenever people have like a question that, as a mediator, that they want somebody to weigh in on, there's a mediator ethics and advisory council that meets a handful of times a year and puts out some opinions. All of the opinions are on the Florida court's website under MEAC, MEAC, dealing with different areas like advertising and procedure and confidentiality, stuff like that. But there's a recent ethical opinion that says the kids get in by mutual agreement. So I've had a few of those. Always go the way people hope for. Frankly, it's still a big burden to put on a kid to kind of have to speak up in that kind of a forum.
Yeah, but, I am lucky enough not to have had to deal with that.
It's tough.
I don't think I should ever, as an attorney, be talking to children.
I think that as a mediator, you're sort of in that kind of, you're always supposed to keep the interest of people who are affected by the mediation outcome in mind. In family, the children are the clearest example of that. In a circuit mediation, if it's like a public service mediation that's going to affect the people in the community, or with a company that is going to affect all the employees, you still have to kind of try to push back with people on the effect that it's going to have on parties affected who aren't in the room. So, if it's going to happen and everybody insists on it happening, you should, I think, push back to make sure that it happens with some provisions in there that it's going to go well, because I agree with you. We're not educators necessarily. We're not counselors. We're not, other than some of us are parents or step parents or whatever the case may be. But
most of us have issues of our own.
We were all kids once, right? That should be enough to send us running for the hills.
So you talked a little bit about confidentiality. What other things would not be confidential in a mediation?
So there are a handful of exceptions to mediation confidentiality. And so the main one is where the parties have waived the privilege. If one side wants to waive the privilege, but the other side doesn't want to waive the privilege, as a mediator, you're probably getting that subpoena, to testify, and you're under the obligation to basically file a, noisy objection saying, no, I can't violate mediation confidentiality with quoting this particular section of the law. But if both sides agree that you should come in and testify, then you can. If there are mediation communications that are associated with planning, committing, or hiding ongoing criminal activity, threatening violence, I'm going to kill you, not confidential. A punch in the face, not confidential. Those kinds of situations are excluded from confidentiality. There are the mandatory reports under Chapter 39 of child abuse and neglect. And those are, we have to do that. We have to report that. If we hear, if it's an unreported situation, then we absolutely have to call DCF. Same under Chapter 415 for any person who's a vulnerable adult. A vulnerable adult is usually a person who is having some kind of a mental disability. Some people think old people, but it is not just older people. It is people who have some kind of a inability to process and defend themselves. People have asked whether this affects people who are in domestic violence situations. No, because if that person is in their full capacity, they may be experiencing violence, but they still have the ability, legal and mental, to be able to push back. So Chapter 415 doesn't cover that situation. To report, prove, or disprove professional malpractice during the malpractice proceeding. The challenge for a mediator is that when you have a dual role, if you're a lawyer who's obligated to report malpractice and a mediator who's obligated to maintain confidentiality, your mediator hat is the one you're wearing when you're mediating. So you have to stick to that, basically. You can give evidence as ground, like the contract disputes, on the contract dispute type of issues, to avoid or reform a settlement reached during mediation. So if people are saying duress, or they're saying, undue influence, or any of the contract disputes, those can be exceptions to mediation.
What about parole evidence? Do you ever run into that?
I have not run into parole evidence. Or nobody has brought it up. I probably have run into it, but nobody's made an issue out of it. Some of these things you see violated all the time, but then nobody makes a big deal out of it.
Your agreements are so crystal clear, there would be no need for parole
I do a lot of writing. Yeah. But who knows? It was said but not incorporated. And just professional misconduct on other areas. The other thing is that just because somebody shares something in mediation doesn't make it automatically protected. And Chapter 44 deals with that, because if it's discoverable through other means, then it can still be.
Like the missing bank account in the Bahamas?
Well, the bank account in the Bahamas is sort of a classic mediator scenario where we are sort of obligated to stop everything. That kind of goes with the, you can't let people wipe their hands with you scenario. You are not, that goes to fraud. You're not allowed to be a part of fraud. You're not, once people tell you, I have a bank account in the Bahamas, but don't tell the other side, now you're being used to do that. So you kind of have to put it back on people and say, okay, I'm not allowed to continue if you're going to be fraudulent about this. So how do you want me to handle this? How do you want me to handle this scenario? And so, speaking of awkward pauses, right? People are like, damn.
So if someone comes to you and asks you advice or your opinion and then puts you in that position, what do you do?
Hey, you can't give that as a mediator. It is not your process. You're not there to provide legal advice. You're not there to say what the judge could do. You're not there to tell people what to do. You're not there to tell people what you think. You can give information that you are, trained to provide by whatever training you have, whether you're an attorney or a mental health professional or whatever background you bring to mediating. It's tricky because people have, you're watching people go through all kinds of different decision-making processes in mediation. And especially when you get to those last stages where people are like, gosh, I don't know, they really have these genuine questions. If they have a lawyer, I would normally refer them back to their attorney, to have the attorney sort of weigh in on what their advice is, because here's the person you're paying for advice, right? And they're on your side and I'm not on anybody's side. I'm here working with both of you. If maybe they need a little more time to think about it sometimes, but as a mediator and a neutral, you're neutral towards the outcome, right? You don't necessarily, you're not supposed to care one way or another how it's going to turn out. So you can't put your thumb on the scale. But that question does come up all the time because it's human. People are trying to think things through.
So how do you know when a mediation is over, and what's the difference between an adjournment and an impasse?
Sure. There's all these ways it can go, right? You can have everywhere from no agreement to like this full signed agreement that gets everything done. Impasse is like no agreement. I always think of the Monty Python, the Black Knight, none shall pass, you kind of want to try to get around that impasse as many times as you can. You kind of take no for an answer a little bit, because sometimes that's kind of where you're really getting going, where people say no. the beginning of the conversation. But sometimes it's really, they're just too far apart. And the mediator can call an impasse, or the parties. One of the parties can just say, I'm done, I'm out. And so that ends it, right? An adjournment, a lot of times attorneys would rather have that impasse because it means they can then go on and see the judge or the magistrate or whoever they have to talk to in court to get a date, to get the process moving again, and it's not going to languish. But an adjournment is useful because it means people are still talking, right? But both parties need to agree to that adjournment. It can't just be something that the mediator says, all right, we're adjourned. If you say, all right, we're adjourned, you better really believe that both of the parties are like, yes, we're adjourned. That it's not one side, yes, says, yes, we're adjourned, and the other one says, no, we're not. Because in that case, what you have is an impasse, not an adjournment.
So we have a duty to mediate in good faith. And, there's a lot of different opinions on what constitutes good faith. What do you think about that?
From my perspective as a mediator, I know it's in the orders. The judges love to put it in the orders, but there is no obligation to mediate in good faith from what I have absorbed. If reaching an agreement, I think that there is a strong benefit to people giving it a try. That for people to sort of prejudge it and say, my case is so good, I don't even need to talk about this, it's a slam dunk, let me go see the judge, can be a real challenge or a real missed opportunity, frankly, sometimes, because even an impasse teaches people something about how the other side is going to behave, where the bullets are coming from. You have the opportunity to learn something new in mediation that will allow you to make an informed decision. Right? Or really, it's essentially a facilitated negotiation process that allows people to make an informed decision. If your informed decision is, I want to go see the judge, that what I'm going to get there, my chances there, and I brought my magic 8-ball. My chances there are better than what the other side is offering, right? That is always every person's decision to make, self-determination, right? What do you miss by not, what do you miss by sort of coming in and saying, give me my trial ticket? I'm not going to waste my time or my client's attorney's fees in here. Maybe that's what you miss, right? New information. But if you really, really do firmly believe that that's in your client's best interest, it's, from my angle, it's an exercise in self-determination. If somebody walks in and just says no.
What I want to know is how many times you've used that magic 8-ball in the past week.
I don't let anybody use it because people are weirdly suggestible, but I used to have it in my office at the courthouse. Threaten people.
Do you really want to leave it up to the stranger in the black robe?
I don't know. Let me see here. It says, it is certain.
Uh-oh. So that's why we don't base our legal advice on the magic 8-ball. Issues with buyer's remorse. What do you do when someone is upset the next day?
I try to run a process that will give people the opportunity to not get there. I think it was like there were some cartoons back in the comic books rather back in the 90s by Neil Gaiman, the Death series, and there's at one point I remember this very vividly. She's talking about the spirit of the staircase, the main character, which is all of the stuff that comes to mind when you walk out the door, like everything you wish you'd said while you were sitting in the chair in the room, and now you're walking out the door, going down the stairs, and that it all comes flooding into your mind at that point in time. And so I think it's important to try to avoid a process that's going to cause people that reaction. You should not hurry it up. You shouldn't, time pressure, money pressure, all those things sort of start feeding in at the end of things. Even now with the digital signatures, I really worry about that. You can just say like click all and it's going to sign something. And then you're like, wait, I didn't want to sign that. You don't want to put people in a situation where they have that moment. But it is inevitably going to happen to some people because some people are slower thinkers. They need more time to absorb and process, and mediation and law and just the pressure of being put on the moment and on the spot and do this sometimes just causes people to do something and then second guess themselves. Or, they were negotiating and there was horse trading going on, and then they're not happy with their deal because it doesn't have something that was important to them for one reason or another. So that's when.
Or they talk to someone else.
That too. Shadow people. Oh, I could have gotten this because so-and-so got this. Or why did you give that up?
We have done a great job discussing the basics of the ethics of mediation. And I know you and I have shared many personal discussions about much more strategic things, ancient texts, even hostage negotiations. So I would like to invite you back someday so we can even delve deeper into some of these cool issues and really elevate our practice to the highest level we can get there, because there's so much information out there that if we employed it, we could take what we're doing and doing it even better.
Thank you. I love coming. Thank you for letting me run on and on about my favorite subject. Teaching the 40-hour course means I can go on about this endlessly. So it creates plenty of opportunities. I'm glad to have a chance to talk about it. Thank you for having me.
You gave our subscribers a half an hour of mediation credit, or ethics credit, I think we're going to get. So we appreciate that. And that brings this edition of Stephen Squibs Monthly Family Law CLE, January 15th, 2020 edition, 2021. I've done it on my check 5 times already this year. Can't get that right. But we'll see you all again next month. And thank you for joining us.
Thanks, Eddie.
Thank you, Christina.
Take care.
Sit tight for a second. Let me stop recording. There we go.